Hello students, today I'll be discussing the topic of constitutional validity of Right to Education Act in India. Introducing the topic, one child, one teacher, one book, one pen can change the world. Malala Yousafzai. Education is a powerful tool by which economically and socially marginalized adults and children can lift themselves out of poverty and participate fully as citizens. It is a fundamental human right and essential for the exercise of all other human rights. It promotes individual freedom and empowerment and yields important development benefits. Yet, millions of children and adults remain deprived of educational opportunity, many as the result of poverty. Normative instruments of United Nations and UNESCO lay down international legal obligation for the right to education. These instruments promote and develop the right of every person to enjoy access to education of good quality without discrimination or exclusion. These instruments bear witness to the great importance that member states and international community attach to normative action for realizing the right to education. It is for the government to fulfill their obligation, both legal and political, in regard to provide education for all of the good quality and to implement and monitor more effective education strategies. The right to education is a universal entitlement to education. This is recognized in International Covenant on Economic, Social and Cultural Rights as a human right that includes the right to free, compulsory primary education for all, an obligation to develop secondary education accessible to all, in particular by progressive introduction of the free secondary education, as well as an obligation to develop equitable access to higher education, ideally by progressive introduction of free higher education. The right to education also includes a responsibility to provide basic education for individuals who have not completed primary education. In addition to these access to education provisions, the right to education encompasses the obligation to rule out the discrimination at all levels of educational system, to set minimum standards and to improve the quality of education. International recognition of education as a human right. There are a large number of human rights problems which cannot be solved unless the right to education is addressed as the key to unlock other human rights. The right to education is clearly acknowledged in the United Nations Universal Declaration of Human Rights adopted in 1948. Which states that every person has the right to education. Education shall be free, at least in the elementary and fundamental stages. Elementary education shall be compulsory. Technical and professional education shall be made generally available, and higher education shall be equally accessible to all on the basis of merit, given under Article 26. Apart from UDHR, right to education is affirmed, protected and promoted in numerous international human rights treaties such as the following: Covenant concerning discrimination in respect of employment and occupation 1958, Article 3, Convention against discrimination in education 1960, International Covenant on Economic, Social and Cultural Rights 1966, Article 13, Convention on the Elimination of All Form of Discrimination Against Women, CEDAW 1981, Article 10, the United Nations Convention on the Right of Child 1989, Article 28 and Article 29. The right to education has therefore long been recognized by these international treaties as encompassing not only access to educational provisions but also the obligation to eliminate discrimination at all levels of the educational system, to set minimum standards and to improve quality. With respect to the applicability of these treaties in India, it is worthwhile to mention that India is a state party to ICSCR, the CRD Convention, the CEDAW Convention and the Convention on the Right to Child. Right to education in India implications and challenges. The enactment of the fundamental right to education still in parliamentary process, but widely expected to become reality soon, is ambitious for a country that has witnessed decades of policy failure to make operational the rhetoric of free and compulsory elementary education for all children until the age of 14 years. Education has been neither free nor compulsory. For the state to guarantee educational provision through a legislative enactment is a major shift given in a history of provision which has consistently failed disadvantaged group, privileging the interest of the minority urban elite. About 110 million children remain out of the schooling system and about 60% of those who enroll in school drop out by grade 8. As studies have consistently shown over time, those excluded continue to reflect inequalities within the wider social, economic and political fabric, particularly those of caste, class and gender. Axes of inclusion are broadly predicted around the following occupational and social classifications. Children of the upper caste or from smaller families or from households that are economically better off or dependent on non-agricultural occupation with parents who are better educated or from villages that have better access to school, thus underlining the role played by social positions, economic opportunity and the power exercised by local community leadership in securing state-provided resources in education. Cutting right across these axes is the gender gap, which is more or less consistent across social groups. The gap between the discourse and operational framework in all policy efforts in education and more widely development has long been cited as a reason for India's poor performance in securing equitable educational opportunity for all. Despite a range of commitments made in Indian Constitution to equality, addressing the historical disadvantage faced by certain groups and universal education policies on the ground have done little to fulfill the ambitious vision developed at the birth of the modern Indian nation state. This gap appears in danger of persisting even with the shift to guaranteeing the right to education. In this section, some of the issues raised by the current approach are explored. Right to education in Indian constitutional perspective. The Indian Constitution is known to be a document committed to social justice. As per expert opinion, literacy forms the cornerstone for making provision of equality of opportunity a reality. The Indian Constitution has therefore recognized education as the essence of social transformation, as is evident from its education specific articles. The judicial decision from which the right to education emanated as a fundamental right was from one rendered by the Supreme Court in Mohini Jain versus State of Karnataka. In this case, the Supreme Court, through a division bench comprising of Justice Kuldeep Singh and R. M. Sahai, deciding on the constitutional of the practice of charging capitation fee, held that the right to education flows directly from right to life. The right to life and dignity of an individual cannot be assured unless it is accompanied by the right to education. The rationality of this judgment was further examined by 5-judge bench in J.P. Unikrishnan versus State of Andhra Pradesh, where the enforceability and the extent of the right to education was clarified in the following words. The right to education further means that a citizen has a right to call upon the state to provide educational facilities to him within the limit of its economic capacity and development. The same has also been reiterated by the Honorable Supreme Court in Bandhu Mukti Morcha versus Union of India, specially referred to the earlier judgment made in this connection as under. In Maharashtra State Board of Secondary and Higher Education versus K.S. Gandhi, the right to education at the secondary stage was held to be a fundamental right. In J.P. Unikrishnan versus State of Andhra Pradesh, a constitution bench had held that education up to the age of 14 years to be a fundamental right. It would be therefore incumbent upon the state to provide facilities and opportunities as enjoined under Article 39 Clause E and Article 39 Clause F of the Constitution, and to prevent exploitation of their childhood due to indecence and vagary. The Right to Education Act (RTE) was passed by the Indian Parliament on August 4, 2009. Guarantees children the right to free and compulsory education. Children from the age of 6 to 18 are entitled to education under the Right of Children to Free and Compulsory Education Act 2009, also known as Right to Education Act 2009 RTE. According to Article 21 Clause A of the Indian Constitution, it outlines the specifics of the significance of free and compulsory education for children aged 6 to 14 in India. India is now one of the 135 nations in the world where the right to an education is a fundamental one because of the enforcement of this law. Features of Right to Education Act 2009. The primary features of Right to Education Act 2009 are that it provides free and compulsory education to all children in India aged 6 to 14. The following are some of the RTE basic features. All children aged 6 to 14 are entitled to free and compulsory schooling. There will be no detention or exam until the elementary school is completed. Compulsory and free education for all. In India, the government is required to provide free and required primary education to each and every child up to class 8th in a neighborhood school within a 1 kilometer radius. Free education also includes the delivery of textbooks, clothing, stationery, and specific education resources for children with disabilities in order to reduce the financial burden of the school cost. No child is compelled to pay any fee or other expenditure that might prevent them from completing their primary education. The benchmark mandate. The Right to Education Act establishes the guideline and requirement for classrooms, boys and girls restroom, drinking water facility, the number of school days and working hour for teacher, among other things. To uphold the basic level established by the Right to Education Act, every primary school in India must adhere to this set of rules. Special provision for special cases. According to Right to Education Act, a child who is not enrolled in a school must be accepted to a class for their age and get specialized instruction to help them catch up the age appropriate learning level. Quantity and quality of teachers. The Right to Education Act ensures that the necessary pupil-teacher ratio is maintained in every school without any urban-rural imbalance at all, allowing for the sensible deployment of teachers. It also necessitates the appointment of instructors with the requisite academic and professional training. Zero tolerance against discrimination and harassment. The Right to Education Act 2009 outlaws all forms of corporal punishment and psychological abuse, as well as discrimination based on gender, caste, class and religion, as well as capitation fee, private tutoring facility and operation of unrecognized school. Ensuring all-round development of child. The Right to Education Act of 2009 mandates the construction of curriculum that ensure each child's full development. It also seeks to improve a child's knowledge, talents and overall potential, improving learning outcomes to minimize detention. No child is allowed to be held back or expelled from school until class 8 according to the Right to Education Act. The Continuous Comprehensive Evaluation CCE system was established in 2009 under the Right to Education Act. It aims to ensure acceptable learning outcome for each grade level in schools. This method was developed to analyze every aspect of the child while they were in school, allowing the gaps to be identified and rectified as soon as feasible. Monitoring compliance of RTE norms. School management committees are essential for enhancing governance and participatory democracy in primary education. All schools covered by the Right to Education Act of 2009 are required to form a school management committee up to of a principal, a local elected official, parents and other community members. The committee have been tasked with developing a school development plan and monitoring how the schools are performing. Right to Education Act is justiciable. The Right to Education Act of 2009 is legally enforceable and is supported by a grievance redressal framework that enables anyone to take legal action against violation of its provision. Oxfam India and Josh filed a complaint with the Central Government Commission in 2011 under Section 4 of Right to Information Act of 2005 to ensure that all schools adhere to this requirement, creating inclusive spaces for all. All private schools must set aside 25% of the seats for children from socially and economically disadvantaged areas, according to the Right to Education Act of 2009. The RTE Act's clause promoting social inclusion aims to create a more equitable and just society. Achievements of Right to Education Act 2009. The RTE's greatest success was in enabling India to reach enrollment rate that were nearly 100%. India has been able to develop its infrastructure after RTE was put into place in 2010. According to Acer Central Annual Status of Education Report, the only source of data on children's learning result in the nation, the percentage of schools with usable girls' restroom doubled, reaching 66.4% in 2018. In 2018, there were 64.4 schools with boundary walls, an increase of 13.4 percentage points from the previous year. From 82.1 to 91% of schools now have cooking sheds. Over same time period, the percentage of schools receiving books other than textbook rose from 62.6 to 74.2%. Significance of Right to Education Act. With the passing of the Right to Education Act, India has moved to right-based approach towards implementing education for all. This act casts a legal obligation on the state and central government to execute the fundamental rights of a child as per Article 21A of the Constitution. The act lays down specific standards for the student-teacher ratio, which is very important concept in providing quality education. It also talks about providing separate washroom facility for girls and boys, having adequate standards for classroom conditions, drinking water facilities, etc. The stress on avoiding the urban-rural imbalance in teachers' posting is important, as there is a big gap in the quality and number regarding education in the villages compared to the urban areas in the country. The Act provides for zero tolerance against the harassment and discrimination of children. The prohibition of screening procedures for admission ensures that there would be no discrimination of children on the basis of caste, religion, gender, etc. The Act also mandates that no kid is detained until class 8th. It introduced the Continuous Comprehensive Evaluation System in 2009 to have grade-appropriate learning outcomes in the school. The Act also provides for the formation of a school management committee in every school in order to promote participatory democracy and governance in all elementary schools. These committees have the authority to monitor the school's functioning and prepare development plans for it. The Act is justiciable and has a grievance redressal mechanism that permits people to take action when the provisions of the Act are not complied with. The RTE Act mandates for all private schools to reserve 25% of their seats for children from socially disadvantaged and economically backward sections. This move is intended to boost social inclusion and pave the way for a more just and equal work. This provision is included in Section Clause 1, Subclause C of RTE Act. All schools, private, unaided or specific category, must reserve 25% of the seats at entry level for students from the economically weaker sections and disadvantaged group. When the rough version of the Act was drafted in 2005, there was lot of outcry in the country against this large percentage of seats being reserved for the underprivileged. However, the framer of the draft stood their ground and were able to justify the 25% reservation in private school. The provision is far-reaching move and perhaps the most important step insofar as inclusive education is concerned. This provision seeks to achieve social integration. The loss incurred by the school as a result of this would be reimbursed by the central government. The Act has increased enrollment in the upper primary level class 6 to 8 between 2009 and 2016 by 19.4%. In rural areas, in 2016, only 3.3% of children in 6 to 14 year bracket were out of school. Criticism of Right to Education Act. Even though Right to Education Act is a step in the right direction towards the achievement of making education truly free and compulsory in India, it has met with several criticisms. Some of the criticisms are given below. The Act was drafted hastily without much thought or consultation being given to the quality of education imparted. Children below 6 years are not covered under this Act. Many of the schemes under the Act have been compared to the previous scheme on education such as Sarv Shiksha Abhiyan and have been plagued with corruption charges and inefficiency. There have been implementational hurdles in the 25% reservation of seats for economically weaker section and others in private school. Some of the challenges in the regard are discriminatory behavior towards parents and difficulty experienced by students to fit in with the different socio-cultural milieu. Regarding the number detention policy, still Class 8, an amendment to the Act in 2019 introduced regular annual exam in Class 5 and 8. In case a student fail in the annual exam, he or she is given extra training and made to appear for a re-exam. If this re-exam is not passed, the student can be detained in the class. This amendment was made after many states complained that without regular exam, the learning level of the children could not be evaluated effectively. The states which were against this amendment were 6 states with higher learning outcomes due to their effective implementation of the CCE system as maintained in the Act. These states were Andhra Pradesh, Karnataka, Kerala, Goa, Telangana and Maharashtra. It has been found that many states find it difficult to move to the CCE system of assessment. This is chiefly due to the lack of teacher training and orientation. Another criticism leveled against the Act is that instead of increasing the standards and outcomes of the public education system in India, it passes the buck to private school with some respect. Coming to the conclusion, it can be concluded that one of the most important pieces of legislation in Indian history to ensure that children receives a basic education is the amendment to the fundamental right to education. The nation's future lies with its children. Education is therefore a tool for introducing a child to cultural values, preparing him for future professional training and assisting him in making a normal adjustment to his surroundings. A child today cannot succeed in life without education. The fundamental right to education applies to everyone equally. The most crucial component of higher education is therefore elementary education. Making the right to education a fundamental right took more than 6 decades after independence. Now, the government and all stakeholders should focus on the quality of education and gradually move towards having a single educational system and platform across the country for all sections of society in order to foster equality, inclusion and unity. Thank you and have a nice day.